Thank you, gentlemen. I'm glad you mentioned the Constitution and that you did some checking about the Constitution. It's one thing to get an opinion on whether or not something is constitutional, and it's another thing to actually cite chapter and verse from the Constitution and see exactly what the Constitution says that might relate to a matter. Being here speaking to senators, all of whom have sworn an oath to support and defend the Constitution, I hope this will fall on friendly ears, and I would direct your attention to Amendment VII, part of the Bill of Rights of the Constitution, which says, in suits at common law where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise examined in any court of the United States than according to the rules of common law. You notice it doesn't mention anything here about a court-appointed receiver. Of course, nobody is required to have a trial by jury. They simply have a right to a trial by jury. And this is what our Constitution says due process is the right to a trial by jury. The importance of a trial by jury, as it has come down through thousands of years worth of history, has been demonstrated in this. When there's a controversy between a citizen and the government, the decision is made by the fellow citizens as to whether what the citizen has done is objectionable or wrong in the view of the citizenry. This is what a free country consists of, where the people are the ones who actually give consent. And we have this system that we call government by the consent of the governed. And so the Constitution is one document which was arrived at through consent. It was ratified. The people gave consent for the government to perform in such a way as described in the Constitution. And they defined in the Constitution that due process is the right to a trial by a jury of your peers, and your peers means your fellow citizens. Now, when you have a controversy that's between a citizen and the government, and the court is run by the government, and the judge is a government employee, and then he goes and hires another government employee, which they're going to call the receiver, you got the fox guarding the hen house.
Now, why do you say the receiver is going to be a government employee?
Well, he's going to be hired by the judge. He's going to be hired by the government, and he will be beholden to those who hired him. He's certainly not hired by the property owner.
He could be.
Well, they might give him some input into it. But once again, all of these choices and input you're talking about are things that are determined by other than a trial by a jury of his peers. The whole essence of the defense of liberty from government oppression and abuse, and you want to tighten down the language, you say, so that you can avoid what might go wrong with regard to vague terms and undefinable terms. But in the final analysis, if the people think that what somebody has done is wrong, if the people of that community look at that building and they see that that building is a hazard, it's objectionable, whatever their standards are. You know, we hear lots of things about public policy. I'm a member of the public. Nobody has ever asked me what my input was. I don't know how public policy is formulated, because as a member of the public, I've never been consulted as to what public policy should be. But we do have a mechanism by which the people do have a voice. One, of course, the ballot box is one where they elect their representatives, but the jury box is another place where the public actually has the opportunity to express an opinion as to whether or not they agree with the position of the government. And of course, if the government represents the people, and we live in a free country, and the government is serving the people rather than oppressing the people, then the common citizen who looks at what the government is doing with an unbiased position is going to agree that what the government is doing is what they should be doing. But if you remove from the whole equation the right of a trial by jury, which is the definition of due process that's given in our Constitution, you really don't have due process. You can create some other mechanism and call it due process, but it's not what our Constitution says in the Amendment VII very clearly and very, very precisely. Now you might say, oh, it's not convenient to do it that way. It'd be too much trouble. It would be too expensive. You know, George Washington, in his farewell address, addressed this very subject. And he said, if in the opinion of the people, the distribution or modification of constitutional powers be in any particular wrong, let it be corrected by an amendment in the way in which the Constitution designates. But let there be no change by usurpation. For though this, in one instance, might be the instrument of good, it is the customary weapon by which free governments are destroyed. The precedent must always greatly overbalance in permanent evil any partial or transient benefit which the use can at any time yield. I mean, these are the people that wrote the Constitution. People want to say, well, what does the Constitution mean? What is it? All that kind of stuff. The people that wrote the Constitution tells us that if you don't like something in the Constitution, the people need to give their consent to the change. You don't just change it by usurpation. Just decide you're going to do it another way because it's not convenient to do it that way. If the distribution of governmental powers that are defined in the Constitution are wrong, then amend the Constitution and make it better according to what we need it to be right now, but don't just seize the power and do it.
So your complaint or opposition to this is because it denies a right to jury trial.
Exactly right.
Okay.
And that is not due process to do this. And now, and of course, everybody is going to point out all about the worthiness and the need for the honorable intent of what has got to be accomplished and doing away with the hazards and the health and safety and all this sort of things. We have a Supreme Court justice by the name of Justice Louis Brandeis. He's not there now. He addressed this very issue. And he said, experience should teach us to be most on our guard to protect liberty when the government's purposes are beneficent. Men born to freedom are naturally alert to repel invasion of their liberty by evil-minded rulers. The greatest dangers to liberty lurk in the insidious encroachment by men of zeal, well-meaning, but without understanding. You see? And so basically what you've got here is a situation where rather than abiding by the Constitution and but proclaiming the worthiness of the cause, we're going to shortcut the Constitution and make up another way of going about accomplishing a worthy cause. We're going to do this beneficent thing with zeal and all of this sort of thing, and it's just going to be more convenient than doing it the way the Constitution says.
All right,
well,
I hear you. I mean, I got that. Do you have another point?
Yeah. Well, you know, the idea of laws being made up, codes and things like that, all of these things, laws made up by unelected bureaucrats who pretend to be representatives of the people.
Well, now you realize we are elected up here.
Oh, yes, you are. That's right.
But
all of these codes, no, but the codes that you're going to
say. The International Building Code, we pass on it every time it comes before us.
Yeah, well, you didn't write that. And where did it come from?
We don't write. I didn't write.
But who wrote the International Building Code?
It really doesn't matter to me who wrote it. A drafter wrote it, but it comes.
It's written at the United Nations.
Well, there's nothing wrong with the United Nations.
Yeah.
Okay. Well, thank you. But Professor, can you address the issue of whether a jury trial is required in this case or not?
Yes. At the time the Constitution was drafted, I'm talking about the United States Constitution, it was well settled in English and American law that there was common law, and equity. Indeed, for a while they said separately. Now we've joined them. The provisions that he referred to would apply to actions at law, not at equity. I realize this is sort of like we're priests of a temple and we're bringing out trick words, but it was divided that way many years ago, centuries ago, for very good reasons why there were things that judges should be doing without juries. So it does satisfy the particular provision that he was referring to. That is not a problem with this particular bill.
Okay. Thank you. Thank you, Mr. Kern. Anybody else who's here? Okay.